Welcome back to the Jurist Prudence channel, the home for summarized case laws, legal definitions and procedures. Thank you for clicking on this video and showing us your love. We cannot emphasize enough on how much we are grateful. If this is your first encounter, and you love law, please subscribe and turn on your notification button, so that you don't miss any of our new crispy fresh videos. However, if you're not sure, you can at least leave us a like. Doing so will not only contribute towards the growth of this channel, but it will also help other law enthusiasts to find and learn from our channel. In this video, we shall be continuing with wrongfulness under the scope of the law of delict. Please refer to our Law of Delict playlist if you need a recap on the definition of delict and to learn about other elements of a delict. In 4.1 we learnt about the legal convictions of the community as the basic test for wrongfulness, the balancing of interests, delictual and an objective criterion. In this video, we shall first look into wrongfulness as an infringement of a right, and evaluate the doctrine of subjective rights. Secondly, we shall discuss wrongfulness as a breach of legal duty and expand on the liability for an omission. A wise man once said, "Success is no accident. It is hard work, perseverance, studying, sacrifice and most of all, love of what you are doing or learning to do." And the blind man said, "Oh, I see." In Universiteit van Pretoria v Tommy Meyer Films BPK, the court accepted the doctrine of subjective rights. The fundamental premise of this doctrine is that wrongfulness consists of the infringement of a subjective right. Legal subjects are holders of subjective rights. The holder of a subjective right has a right to something enforceable against other people. This indicates the dual relationship that characterizes every right. Here's a quick law of persons recap. The subject-object relationship is the relationship between the holder of the right and the object. The law determines how a person may use, enjoy and alienate his legal objects. Whereas the subject-subject relationship is a relationship between the holder of the right and all other legal subjects. The holder of a right can uphold his powers over a legal object against all other legal subjects, and as a corollary, that a duty rests on all other legal subjects not to infringe the relationship between the holder of a right and the object of his right. The nature of a subjective right is largely determined by the nature of the object of the particular right. The 5 classes or categories of rights are namely, real rights, personal rights, immaterial property rights and personal immaterial property rights. Nothing prevents the further development or evolution of the doctrine of subjective rights. Subjective rights arise when the law recognizes existing individual interests as being worthy of protection. For an object to be legally recognized and protected, it must be of value to the holder of the right. Meaning it must be relatively scarce, and be of economic or sentimental value. Secondly, the object must have a measure of independence. Meaning it must exist separate from the legal subject. The fundamental premise of the doctrine of subjective rights is that the infringement of such a right is wrongful. In determining whether a right has been infringed, a dual investigation is necessary. One must first determine whether the holder of a right was disturbed in the use and enjoyment of his right. If so, one must then establish whether the infringement complained of took place in a legally reprehensible way. If this is established, the conduct is wrongful. However, there are circumstances in which it is more appropriate to determine wrongfulness by asking whether a legal duty has been breached, than by asking whether a subjective right has been infringed. This brings us to liability for an omission.
Liability for an omission can be interpreted as circumstances where one may be held legally responsible for not doing something. In cases of liability for an omission, or for causing pure economic loss, wrongfulness is normally determined not by asking whether the plaintiff's subjective right has been infringed, but rather by asking if according to the boni mores or reasonableness criterion, the defendant had a legal duty to prevent harm. Pure economic loss is a financial loss or damage suffered by the plaintiff, exclusive of any physical injury to his or her assets and resulting from a negligent act of another party. According to the boni mores criterion, there is neither a general duty to prevent loss to others by positive conduct, nor a general duty to prevent pure economic loss. It was submitted in Van Eden v. Minister of Safety and Security that an omission is wrongful if the defendant is under a legal duty to act positively to prevent the harm suffered by the plaintiff. The test to be adopted here is one of reasonableness. If it is found that the defendant indeed had a legal duty, a breach of that duty is, in the absence of a ground of justification, unreasonable, contra bonos mores, and thus wrongful. The question of whether such a duty existed is answered with reference to the flexible criterion of the legal convictions of the community and legal policy. All factors which, according to the convictions of the community, which may be indicative of a legal duty to act positively, must be considered and applied in line with the Bill of Rights. Omissions are generally considered lawful. However, there are exceptions. A person acts prima facie wrongfully when he creates a new source of danger by means of positive conduct, and subsequently fails to eliminate that danger, with the result that harm is caused to another person. 1. Prior conduct in the form of a positive act that creates a danger of harm, may in other words be a strong indication that a legal duty rested upon the defendant to take steps to prevent the damage from happening. If one creates a circumstance where there could be a danger, one must take precautions to prevent that danger. It is noteworthy that prior conduct is neither a prerequisite for the existence of a legal duty nor an essential requirement for wrongfulness. Other relevant factors may be considered. However, the view that prior conduct is an essential requirement for delictual liability for omissions prevailed in South Africa for a long time. 2. Control over a dangerous or potentially dangerous object, situation or person, for example a dangerous criminal, can be a factor in determining whether a legal duty rested on the person in control to prevent someone from being injured by the particular situation. The two relevant questions are, firstly, whether there was actual control, and secondly, whether in light of inter alia such control, a legal duty rested on the defendant to take steps to prevent damage resulting from his or her omission to exercise proper control. Control can be assumed from the fact that the defendant had actually taken control over the potentially dangerous situation, or that the defendant was the owner or occupier of the potentially dangerous object. The fact that the defendant had control of a potentially dangerous object is in itself not necessarily sufficient to establish a duty to take precautionary measures, but may be a factor in determining such a duty. It was held that the occupier of property or a building where potentially dangerous conditions exist has a legal duty to prevent injury to persons, even trespassers, who visit the premises. A legal duty may also rest on the owner, occupier or controller of property to control the fire on such property. The same applies to a person in possession of a firearm or dangerous animal, or the police in control of a dangerous prisoner, or a teacher in control of a dangerous learner. With regards to a private swimming pool or a fish pond, it has been held that the owners are not liable where a small child who is brought onto the premises, in the custody and under the supervision of a parent, is injured when falling into the pool, as it is accepted that the responsibility for the safety of little children rests primarily on the parents. If a legal duty exists, injury resulting from the omission to control the dangerous situation is prima facie wrongful. To avoid liability, it has to be clear either that the defendant's apparent wrongful omission was lawful, or that he had taken reasonable steps to prevent injury. Having knowledge or foresight that your omission might cause harm is indicative of the unreasonableness and therefore wrongfulness of your conduct. Where a person was aware of a dangerous situation, this may be a factor in determining whether he had to exercise control over the danger and, consequently, whether a legal duty rested on him to take steps to avert loss. The legal duty with control over a dangerous or potentially dangerous object is vested upon the defendant, if she or he was aware of the dangerous situation. If the defendant was not aware of the danger, a legal duty to act is absent. 3. Sometimes a statute will place an obligation on a person to perform certain acts. A statutory provision can by implication itself grant a delictual action, or it can justify a conclusion that a common law legal duty exists. The conduct will be wrongful, not due to the non-compliance with the statutory legal duty per se, but rather because it is reasonable in the circumstances to compensate the plaintiff for the infringement of his right. Reasonableness is determined with reference to the legal convictions of the community and legal policy. Taking statutory provisions into account is of particular significance when it must be determined whether governmental bodies and state institutions are under legal duties to prevent damage. A statutory provision on its own is not necessarily sufficient to ensure the existence of a legal duty, and is usually considered in interaction with other factors to determine the wrongfulness or otherwise of an omission in a given case. 4. In certain instances, the existence of a special relationship between the parties may be an indication that the one party had a legal duty towards the other to prevent harm. The existence of a contractual relationship may indicate such a legal duty. Other examples are the relationship between a policeman and a citizen, an officer of the law or a warden and a prisoner, an employer and an employee, a parent and a child, and a doctor and a patient. To determine whether a legal duty to prevent damage exists, each case must be measured against the boni mores criterion in the light of all the circumstances, including the special relationship between the parties. 5. Sometimes the person's occupation or the office he holds places a legal duty upon him to conduct himself in a particular manner in relation to the public or certain people. In Macadamia Finance Limited v. DeWitt, the defendants, who were liquidators, inter alia, failed to insure the assets of the first plaintiff, a company under their control. The court stated that the office held by a person sometimes places a legal duty upon him to act in a certain manner towards the public or specific persons. Such a duty existed in casu, and the defendant's breach of that duty rendered them liable for the first plaintiff's resultant loss. 6. A legal duty can arise from a contractual undertaking for the safety of a third party. If A enters into a contract with B, whereby A agrees to ensure the safety of C, A will be under a legal duty to prevent harm to C. For instance, a lifeguard is under a legal duty to take steps to assist a swimmer who is in danger of drowning by virtue of his contract of employment with the local authority. 7. As in Compass Motors Industries Tite Limited v. Calgard Tite 1990, a legal duty can also arise from creation of the impression that the interests of a third party will be protected. Where one party acts in reasonable reliance on the impression created by another party that the latter will protect the person and property of the former, a legal duty rests upon the party creating the impression to prevent prejudice to the party acting in reliance on that impression. The danger of limitless liability can influence the decision whether an omission is wrongful, as well as the fact that the plaintiff was vulnerable to the risk of damage is a further policy consideration that can be taken into account in determining the presence of a legal duty. However, where the plaintiff can protect himself against such damage, for example where by reasonable means he can avoid making himself vulnerable to the risk, but did not do so, this would be an important indicator that the defendant did not act wrongfully. Lastly, the causing of damage by means of conduct in breach of a statutory duty is prima facie wrongful. In other words, non-compliance with a statutory duty is an indication that the violation of the plaintiff's interests took place wrongfully. We hope you're not snoozing. Let us know which voice you found easy to follow, between the blue suit and the black suit. If this was not a waste of your time, please like and share with your colleagues. Take care. This is the Jurist Prudence channel. Forever your law buddy, until the jury do us apart.